Companies Act, Section 462, Power of Central Government to grant exemptions to certain classes of companies. Section 462 of the Companies Act, 2013 provides the central government with flexible authority to relax or modify the applicability of legal provisions for specific categories of companies. This is done in order to serve the broader public interest, promote ease of doing business, reduce compliance burden where appropriate, and support specialized business sectors such as small companies, government companies, charitable entities, or companies working under unique operational structures. The purpose of this section is to ensure that corporate regulations remain balanced, context-appropriate, and adaptable to the needs of different types of companies functioning in India's dynamic business ecosystem. 1. Central government's authority to issue exemptions. Some provisions of the Companies Act shall not apply to a particular class or classes of companies. Certain provisions shall apply but with exceptions, modifications, or necessary adaptations as specified in the notification. This ensures that the legal framework governing companies is not one-size-fits-all, but instead can be customized to suit their scale of operations, nature of functioning, regulatory risks, and economic importance. Examples of cases where exemptions may apply. Private companies, small companies, government companies, companies established for charitable purposes, nidhi or producer companies. 2. Parliamentary oversight before issuing notification. Every proposed notification must be placed in draft form before both houses of Parliament. The total duration for which it must remain before Parliament is 30 days during session time. Parliament has the right to reject the notification entirely or approve it with modifications. In such cases, the notification shall not be issued if both houses disapprove it. The government must issue it only in the modified form if modifications are approved. This ensures checks and balances, maintaining transparency and accountability in the exemption process. 3. Calculation of the 30-day parliamentary period. When counting the 30-day period, any time during which either house is prorogued or adjourned for more than 4 consecutive days shall be excluded. This guarantees a full and fair review period, preventing procedural loopholes. 4. Final notification to be placed before Parliament. A copy of every final notification must again be laid before both houses of Parliament at the earliest possible opportunity. This reinforces ongoing legislative supervision and ensures transparency in the execution of delegated powers. Significance of Section 462. Promoting business convenience and reducing unnecessary compliance burden. Ensuring differential treatment where justified based on corporate size, purpose, and risk level. Enabling rapid regulatory adjustments without requiring frequent legislative amendments. Maintaining parliamentary control over major exemptions affecting corporate governance. Encouraging entrepreneurship and growth by supporting specific sectors. For more details, contact us.